the petitioners, and with me are my learned brothers Silk, namely Iyitayo Jegede SN,
yes,
Professor Mike Ozekome SN, Nella Andem Ewa Rabana SN. And my lords, permit me with respect to replace absent number 5 with my brother Silk Joe Abraham SN. Then number 6, Professor Maxwell M. Gidado SN.
yes,
7, Chief Godi Uche SN.
yes,
8, A.K. Ajibade SN. And with us, my lords, our learned friends, Silas Joseph Ono Esquire,
yes,
and Jude A. Daniel Esquire. Together, my lords, we appear for the petitioners. We are grateful, sirs.
yes. Thank you. Second respondent. Oh, sorry, first, sorry.
May it please, my lords. I am Sir Stephen Adehi. I appear with my learned friends, Senior Counsel, T.M. Inua, SAN, Al-Hassan A. Umar, SAN, Suleiman Olawale Ibrahim, SAN, and my appearing with us are our learned colleagues, Nasara H. Auta, Esquire, Aminu Sadauki, Esquire, M.A. Atta, Esquire, Susan A. Imoisi, Esquire, Jamiu Aguru, Esquire, and Martins F. Ekpa, Esquire. We appear for the first respondent.
Thank you.
May it please, my lords.
Thank you.
With profound humility to my noble lords, my name is A. Malik. I appear, my lord, for the second respondent. Learned brothers of the Silk, Babatunde Ogala, SAN, Dr. Remi Olatubora, SAN, and Mutalubi Ojo Adebayo, SAN, all appear with me. And we have our other colleagues, Emmanuel Uwadoka, Esquire, Yinka Ajenifuja, Esquire, Akintola Makinde, Esquire, Julius Shola, Esquire, and lastly but not the least, Taiwo Lakanu, Esquire. Together, my lord, we appear for the second respondent. Grateful, my lord.
My lords, for the third respondent,
Yes.
I am Charles Uwensuyi Edosawa.
Yes,
My lords, my learned friends, Chief Adeni Akintola, SAN, Chief Afolabi Fashanu, SAN, Sam Ologunrisha, Esquire, SAN, Solomon Umar, Esquire, SAN, Abdul Muhammad Rafin Dadi, Esquire, SAN, and my learned friends of the Outer Barter, Mr. Omose Akpopola, Mr. Olarewaju Akinshola, Mr. Bolaji Oyun, and Ms. Huwaila Muhammad Ibrahim. They're all with me, sirs, for the third respondent. Most grateful, sirs.
Well, we shall deliver the judgments, but you know that we all know the rules concerning consolidated matters. Each of the petitions, though consolidated, will maintain their individual identities, so we shall treat them as such. We shall begin with petition number 4. Well, we all remember that during the pre-hearing session, several motions were filed. So we shall begin with the consideration of these applications before we proceed to the main petition. So in this petition, that's petition number 3 and number 4, sorry, the petitioner herein, Allied People's Movement, participated in the presidential election conducted by the first respondent on the 25th of February 2023 by sponsoring a candidate, that's Wajay Princess Chichi, agreed by the declaration and returned at the election, has via its petition filed on the 20th day of March 2023, prayed this court at paragraph 31 of the petition to grant it the following reliefs. 1, that it may be determined that A, the third respondent was not qualified to contest as the presidential candidate of the second respondent, as at 25th day of February 2023, when the presidential election was conducted by the first respondent in the Federal Republic of Nigeria, having violated the provisions of Section 142, sub 1 of the Constitution of the Federal Republic of Nigeria 1999 as amended. B, a declaration that the return of the third respondent by the first respondent as the president-elect of the Federal Republic of Nigeria is null, void, and of no legal effect whatsoever. The third respondent, having violated the provisions of Section 142, sub 1 of the Constitution of the Federal Republic of Nigeria 1999 as amended, and the fourth respondent, having violated the provision of Section 35 of the Electoral Act 2022. C, the fourth respondent was not qualified to contest as the vice presidential candidate of the second respondent as at 25th February 2023, when the presidential election was conducted by the first respondent in the Federal Republic of Nigeria, having violated the provisions of Section 35 of the Electoral Act 2022. D, the declaration and return of third respondent by the first respondent on 1st March 2023 as the president-elect of the Federal Republic of Nigeria is invalid by reason of non-compliance with the provisions of the Constitution of the Federal Republic of Nigeria 1999 and the Electoral Act 2022. A declaration that having regard to the joint ticket principle enshrined in Section 142(1) of the Constitution of the Federal Republic of Nigeria 1999, the withdrawal of the first respondent as the vice presidential candidate of the second respondent by operation of law amounted to automatic withdrawal and invalidation of the candidature of the third respondent as the presidential candidate of the second respondent for the presidential election conducted by the first respondent on the 25th day of February 2023. A declaration that arising from the invalidity of the third respondent nomination, the first respondent ought not to have included the name or the abbreviation of the name or the logo of the second respondent in the ballot papers and other election materials used by the first respondent for the conduct of the presidential election held on 25th day of February 2023. The fourth respondent was not qualified to contest as the vice presidential candidate of the second respondent as at 25th February 2023 when the presidential election was conducted by the first respondent in the Federal Republic of Nigeria, having violated the provisions of Section 35 of the Electoral Act 2022. An order nullifying and voiding all the votes scored by the third respondent in the presidential election conducted by the first respondent on 25th February 2023 in view of his non-qualification as a candidate of the second respondent. Upon the grant of prayer for above, an order nullifying and or setting aside the return of declaring of the third respondent as winner of the election conducted by the first respondent for the office of the President of the Federal Republic of Nigeria on the 25th day of February 2023, same having been made in violation of the provisions of Section 142(1) of the Constitution of the Federal Republic of Nigeria 1999 and Section 35 of the Electoral Act 2022. And finally, upon the grant of prayers 5 and 6 above, and in the absence of the third respondent's participation in the presidential election held on 25th February 2023, pursuant to Section 136 sub 2 of the Electoral Act, an order declaring the candidate with the next highest number of votes as the winner of the election. The grounds of the petition as set out in paragraph 15 of the petition is as follows. Your petitioner states that the ground upon which this petition is presented is that the third respondent was at the time of the election not qualified to contest the election. The respondents were duly served the petition and also responded by filing their replies. The first respondent reply to the petition was filed on 9th of April 2023. The second respondent reply to the petition was also filed on 9th of April 2023, while that of the third and fourth respondents was filed on 13th of April 2023. The fifth respondent also filed replies to the petition on the 16th of April 2023. The petitioner then filed replies to the respective replies of the respondents to the petition. The respondent filed a number of motions, all of which challenge the competence of the petition. These motions were duly heard during the hearing session and ruling reserved. The first motion was filed by the first respondent. Applicant here in this motion was filed on the 6th of May, wherein he sought the following reliefs. 1. An order striking out paragraphs 2, 3, 4, 5, 6, 7, 13, 14, and 15 of the petitioner reply filed on 20th day of April 2023 in response to the first respondent's reply. 2. An order striking out paragraphs 8, 9, 10, 11, and 12 of the petition reply filed on 20th of April 2023 in response to the first respondent's reply. And for such further orders as the Honorable Tribunal shall deem fit to make in the circumstance. We were urged to note that the grounds for the petition or for the application are as follows. They have been reproduced in the ruling. I need not read them out. So the motion is supported by an affidavit of 4 paragraphs and a written address. The petitioner respondent then responded by filing counter affidavit of 7 paragraphs on 13th of May 2023. Same was accompanied by a written address in opposition to the application. The arguments of counsel in respect of that application have been considered is here in the ruling. A similar application was also filed by the second respondent on the 8th of May 2023, wherein the second respondent prayed this court to grant the following reliefs. 1. An order of the Honorable Tribunal granting leave to the second respondent applicant to file and argue this application before or outside the pre-hearing session in this petition. It should be noted that this court is sitting as the Court of Appeal, not as a tribunal. So, an order of this Honorable Court striking out paragraphs 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15, 16, 17, 17 sub 1, 2, 4, and 5. Paragraph 18, 19, 20, 21, 22, 23, and 24 of Part D of the petitioner's reply and or the entire petition reply to the second respondent's reply to the petition for being an unnecessary repetition and or introduction of new facts unrelated to the second respondent's reply to the petition. 3. An order of the Honorable Court striking out in whole or part thereof of the witness statements on oath filed together with the petition reply to the petition for being irregular and in flagrant non-compliance with the relevant provisions of the first schedule to the Electoral Act 2022. The grounds for that application have also been summarized in this judgment, the same thing with the submissions of counsel. The third and fourth respondents also filed a motion on the 13th of May 2023, seeking the following reliefs. 1. An order striking out the entire reply filed by the petitioner on 20th April 2023, together with the accompanying witness statements on oath, list of witnesses to be relied on, and the list of additional documents. 2. Further, or in the alternative to prayer 1 above, an order striking out paragraphs 1, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15, 16, up to 21 of the petition reply under the heading Petition Reply to the third respondent's reply to the motion filed on 20th April 2023 to the applicant's reply to the petition, and for such further orders as this Honorable Court may deem fit to make in the circumstances. The grounds have also been referred to in this ruling. We have also considered the submissions of counsel. Now, it is apparent that the first respondent's motion filed on the 6th of May 2023, the second respondent motion filed on the 8th of April 2023, and the third and fourth respondent motion filed on 13th May 2023 are all aimed at having certain paragraphs of the petition replies to the respective replies of the respondent's replies to the petition struck out. The common ground in all the applications is that the averments in the petitioner's reply have introduced new facts, new issues, facts, and or grounds to the petition. Furthermore, that some of the averments are rehash or repetition of the averments in the petition file. That those averments in the petition replies offend paragraph 16, subparagraph 1A and B of the first schedule to the Electoral Act 2022. The said paragraph to the Electoral Act stipulates that of his case, which the petition has not dealt with, the petition shall be entitled to file in the registry within 5 days from the receipt of the respondent's reply, a petitioner reply in answer to the new issues of fact, so that A, the petitioner shall not at this stage be entitled to bring in new facts, grounds, or prayers tending to amend or add to the contents of the petition filed by him, and B, the petitioner reply does not run counter to the provisions of paragraph 14.1. In my view, the provisions of paragraph 16.1 of the first schedule to the Electoral Act 2022 are clear, unequivocal, and unambiguous. It does not, therefore, require any text. A holistic reading of that provision, it will be seen that it is meant to explain the purpose of petitioner's reply to the response. Is to raise answers to the text or any fact which must be specifically pleaded and which have the effect of destroying the respondent case or make it not maintainable. The bottom line is that a petitioner is permitted by the first schedule to the Electoral Act 2022 to file a reply where the respondent to the petition has in his reply raised new issues of fact in the petition, which fact the petitioner has not dealt with in the petition. However, in doing so, the petitioner reply shall not introduce new facts, grounds, or prayers tending to amend or add to the contents of the petition. I've cited the case of APC and PDP citations applied. It is therefore clear that paragraph 16.1 of the first schedule to the Electoral Act does not permit a petitioner in his reply to introduce or bring in any new issue or fact which ought to have been raised in the petition itself. In other words, a petitioner cannot, in the guise of a reply to a respondent's reply, introduce a new issue or fact which was never raised in the petition nor raised by the respondent. To do that will amount amending or adding to the petition and also taking the respondent by surprise, because at that stage the respondent will not be in a position to react to such new issue or fact. It will therefore breach the respondent's fundamental right to fair hearing. Therefore, the petitioner is not permitted to repair or rehash his averments in the petition in such a way that it will amount to an amendment or restructuring or a reconstruction of the petition. See the case of Dingyadi and Wamako citations supplied. With the state of the law as stated above at the back of my mind, I have endeavored to scrutinize the pleadings in the respondent's respective replies to the petition, vis-a-vis the specific paragraphs of the petitioner replies complained of. I start with the first respondent complaint. The first respondent complaint is against paragraph 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, and 15 of petitioner reply. I have carefully studied those paragraphs of petitioner reply. It is my view that paragraphs 1, 6, 7, 8, 12, and 14 of petitioner reply to the first respondent reply are competent, as they are proper replies to the first respondent's reply.